Welcome everyone to the June webinar in SPSP's 2025 webinar series. Appreciate you showing up. My name is Ken Ross. I am the webinar coordinator for SPSP, and I'll also be speaking to you today. I want to thank Sedgwick Brand Protection, as always, in sponsoring the 2025 webinar series. We appreciate their participation and support. I want to first do a couple of administrative things and then we'll get started. First, we have some upcoming events for SPSP. We'll take a break over the summer on the webinars. We have a webinar on artificial intelligence in September. Professor Alan Abrams and some of his colleagues will be presenting on some interesting issues about how companies are using AI for product safety. In October, we'll do a program on how to develop a compliance program that is consistent with the CPSC's requirements. And then I'll be filling in for the rest of the year when I get a moment to pick some more topics. Next week, we're going to be sponsoring our first members-only networking event. We've got a couple of speakers to talk about their predictions on the future of the CPSC, which is a timely topic. First time that we've done a members-only event, and we're trying to, of course, encourage people to become members and then participate. So you should have received an email on this event if you are, I think it was sent to everyone, not just members. Then in September, we've got our Advanced Practices in Product Safety program. September 17 and 19 will take place at the 3M Innovation Center in the Twin Cities of Minnesota. And we're putting together the agenda right now and the speakers. That'll be out as soon as we get it done. But the announcement you've already received and that is on our website shows the topics that we will be covering. And registration has opened for that program already. Okay, so today's program, I'll be giving an introduction on the legal aspects of this, which are really important on these topics. Mark Hickok will be talking about the practical aspects of doing that. And Mark, I think did I misspell your name, I think?
No, it's here. It's good.
Is that good enough? Okay.
Exactly right. Thank you.
Okay. From Milwaukee Tool, and then Roland Schindler will be talking to us. Roland is both a product liability lawyer and more recently a patent lawyer. So he's got interesting cross-fertilization of ideas and experiences that will be relevant here. Here's our little disclaimer. Nothing that we say today is necessarily represents the views of any of our clients or former clients or future clients or anywhere in the world. So let's get started on this. And I just want to mention that I will be posting an article I've written on this topic, which has a lot more discussion about the law and some suggestions about how to deal with these issues. But I will tell you, because I've done this now for many decades, even back in the 1970s when I was an in-house lawyer, I was reviewing patent applications. I was dealing with post-sale safety improvements. I was defending product liability litigation. And there is an interplay with all of these things, which is actually very fascinating. Secondly, I'm a member of the American Law Institute, and we created a restatement of product liability in the late 1990s. And we struggled with the law in this area. And the reason is that the law wants to encourage companies to make safety improvements. It does not, and it wants to encourage them to have different products with different levels of safety. That's okay. But how do we do that and still make the products safe enough? And we struggled from a legal side to try to figure out how to do this. So you're going to see some language from the restatement, which will show you kind of the struggle that we have here. And the law, believe it or not, if you're not a lawyer, really doesn't want to make your jobs harder than they otherwise are. So we're trying to do that, yet provide a way to have safe enough products that have minimal risk. So that is one of the struggles, and it's kind of fascinating in this area. And Mark will tell us how he applies this law and these concepts in a practical way. So the main concept in the law in defective design is, could the foreseeable risks have been reduced by adoption of a reasonable alternative design? The key term, reasonable alternative design at reasonable cost. So the question is, can we make our product safer, and should we make it safer? And would that improved product have prevented the accident? And in a product liability case, the way this happens is we have the current product design involved in the accident, and then the plaintiffs come up with experts who say, I could have made it safer, and they should have made it safer. So as a result, all of the things that we're going to talk about today go to that question. Because what happens is that the kind of evidence that a plaintiff is going to use in this area, one would be, let's say you have different levels of safety, different for different uses of the product. Some safety devices may be appropriate for some uses and not necessary or appropriate for other uses. So that's one issue that where the question of having a reasonable alternative design could come up. Secondly, and I've had this situation as an in-house lawyer where we were required to use a safety device in Europe that we weren't required to use in the US. And we lost the case because the jury thought we should put that safety device on our products in the US. So that's similar to optional safety device. It's just an inconsistent level of safety, either within the US or from the US to outside countries. So it's evidence that a plaintiff's attorney can use to show that you could have made the product safer, and you have actually made the product safer. So it's not even speculative. The third type of evidence is that you made a post-sale safety improvement that could have been developed before sale. So you sell a product, you have accidents, you decide to make an improvement in the product, and then which we'll get to in a minute, and you put it on new products that are being sold. So the question is, you could make it safer. Why didn't you do it before this accident happened? So all of these areas, all the areas we'll talk about today, are evidence, can be used as evidence to prove that your product did not contain, it was not safe enough, and there was a reasonable alternative design that you could have put on the product before this particular accident occurred. So on the optional safety side of this is where you have different levels of safety for some products, and not that many products have this, but I kind of use the Sears Roebuck example of the good, better, and best. So there are some products out there where there are actually safety devices that are appropriate to use in some settings and not in others. So to the extent you have inconsistent levels of safety, that is potentially a dangerous area. And because it shows that you could make them safer. And oops, sorry about that. I didn't mean to do that. Okay. So, and it is also then proof that it could be made safer. And again, this could be whether you sell one level of safety in the US and another level of safety in another country. That could be considered then an inconsistent level of safety, even though all you were doing in Europe or somewhere else is complying with their particular safety standards, which were more rigorous. So anytime you have a different level of safety, you have to consider whether that safety level of safety or the higher level of safety would be appropriate to use worldwide. That is one of the issues you're going to have to deal with. Some courts have said in the US that there's no such thing as an optional safety device. That if you have a safety device that is available and is being used and sold in some place in the world, you need to do it in the US. The example I can give you is the one I had, again, as an in-house lawyer involving chainsaws, where there's a particular safety device required in Europe that wasn't required in the US. And so in Europe, we sold the chainsaw with that additional safety device. That came into evidence in the product liability case, and the jury wondered why we wanted to provide a safer product in Europe than in the US. That was a reasonable alternative design, and we lost the case. So, but there are exceptions. So if you can justify that your less safe product is safe enough, the fact that you have safer products doesn't automatically mean that the less safe product is defective, but you may have to explain to a judge or jury why that product without the additional safety device is reasonably safe for its intended use. A court has said this, that here's how you can, I won't go through this in detail. We'll be posting these slides. You can look at it later, but there's a way that if you did have optional safety, this is how you can do it. And what you're doing is you're putting the burden on the buyer to evaluate the safety of their particular application, that they understand that you can use this optional safety feature for these kinds of uses, but you don't need it for other kinds of uses, and put the burden on the buyer basically to decide whether to have that safety device or not. In those cases, the courts do say that you could have an optional safety feature. You know, a normal consumer that's not experienced with certain kinds of products, it might be harder in that setting. So there is a way to sell optional safety, but you want to consider the legal requirements for that and how you can then put the burden on a knowledgeable buyer to make that decision. Okay, so that's optional safety in general. The next area is the post-sale duties. There is what's called in the law post-sale duty to warn, and that is basically that you sell your product, you had no need to warn or design about certain hazards, but then you identify hazards revealed by user operation brought to your attention, and they may impose on you a duty to warn the consumer about this risk that was not known when you sold the product. Now we'll get to the question of, do you have to just warn or do you have to actually do something about it, and how do you do that? We'll get to that in a second. Now this is from the restatement of products liability. And the law on one hand wants to encourage people to make safer products, and on the other hand, it doesn't want to impose such a duty on that post-sale safety improvement can be used against you in a product liability case that would then discourage you from making safer products. So we struggle with those two situations and how they interplay with each other. So here's again some language from the restatement. So one, they don't want to say every post-sale safety improvement gives rise to a duty to warn users, because it would be unacceptably great. And it acknowledges that you redesign products to become safer over time, and we're not going to trigger a common law duty to warn. But then the question is, okay, so that's fine. We appreciate that, but what do we do about it? Now, in any product liability case, if you have had accidents, you've made a safety improvement, you then have accidents, you make a safety improvement, you put it just on new products, you do not offer the safety improvement to prior customers, and you have more accidents, the plaintiff's attorney is going to say you should have either warned the consumer about these hazards you've identified, or offered the safety improvement to prior customers for them to purchase or put on their product. But we'll get to that in a second. So the issue when you get to post-sale safety improvements is, particularly if they are a result from an accident, is do you make a running change? Do you put it just on new products, or do you offer it to prior customers? And I'll just tell you that that's a very critical decision that has to be made both from a safety standpoint and a legal standpoint. So then the other question is, could that alternative design or safety improvement been developed earlier? So you need to really think about these kinds of things. This is not just an engineering issue, a marketing issue. There are legal ramifications, and therefore consulting with experienced product safety, product liability counsel when you make safety changes would be very useful to justify, to make a decision, and to document the file to justify why you believe that decision was adequate, So in the event there are future accidents, you can explain why you do not believe, for example, that you had to offer that safety improvement to prior customers, and what's the basis for that. So, but that's perfect evidence to be used by a plaintiff's attorney in the event you make these things. Now, when you make the post-sale safety improvement, what does the law say about whether you have to inform consumers about that improvement? Again, based on that law that some of the statements I read to you earlier, the law generally says, well, you can make a safety improvement. You don't have to tell your prior customers about it. However, if you know who all your customers are, the cost of warning is negligible, you have a continuing relationship with consumers in some respects, but maintenance or troubleshooting or whatever, maybe you would have a duty to warn them about or inform them about the safety improvement. So generally, the law is pretty narrow in that area. However, if you make a significant safety improvement and you determine that safety improvement may allow a jury to conclude that your product in the field is defective, at that point, then maybe you need to inform prior customers about that safety improvement. Recent case, California Court of Appeals dealt with this exact issue. The manufacturer was negligent for not informing its prior customers that an optional safety device was now mandatory, and for not attempting to retrofit products that did not have the safety device. So it's just the plaintiff's attorneys love to have inconsistent levels of safety, either before sale or after sale. And you need to prepare yourself to explain why what you did at any particular time was appropriate and responsible and contributed to the level of safety that you would expect for these products. So you don't want to be calling lawyers after you get sued and look back at these situations and have to deal with it. It's too late at that point. You've got to think about this, you've got to make a decision that is based on consideration of legal facts and consideration of safety, and move forward with that. And then, do you have to just warn, or do you have to offer the safety improvement? Again, that's an evaluation of whether the new safety device could be considered to make the earlier product defective if they don't have it. How hard is it to find your consumers? Can you charge for the safety improvement? I'm always asked about that, and my response has always been yes. If the consumer would have paid for the safety device that originally, then if you offer a safety device that was developed post-sale, I think you can offer it for sale. But it depends on how much it is. And I've always said you don't want to make a profit by offering a safety improvement to prior customers. So there's a careful way of doing that. So anyway, there's a lot of issues there of deciding whether you're just warning or whether you actually are going to offer the retrofit. Okay, I'm going to stop at this point because we'll start with Roland's slides, but Roland is going to wait until Mark jumps in and tells us, okay, so what do you do now, Mark? So I'll turn it over to you.
Thanks, Ken. You said a lot of great things and a lot of stuff that I think it's easy to say, and I think you did exactly right. But when you get down to it, guys, it's really sometimes hard to do. And as a manufacturer of power tools, we're constantly faced with things that can hurt people. They have products that have a lot of ability to do things. There's a lot of energy. There's a lot of things that can cut, and they're meant to do work. And so we have to kind of balance this concept of risk utility, which is we could do a webinar just on that. So we won't get deep into that concept. But at the end of the day, that's really part of what you're doing is like, you've got to know the purpose of your product. You've got to know why you're doing what you're doing. And as you look at what they're going to do with it, are there risks that you have to address? And there are. And are you addressing them effectively? And if you have these optional things, is it really optional, or is it you just don't want to do it? And it could cost money. It could be hard, but that's not an insignificant analysis. And one of the things that I like to spend a lot of time with, hit my computer. One of the things I love to spend a lot of time with is doing a very strong risk assessment on the front end. At our company, we call it a hazard analysis review. You can call it what you want, but really getting to the heart of the matter makes a difference. because it takes some of that speculation out. It takes a little of the marketing out. It takes a little bit of the cost and some of those things out, because you're literally looking at what is the hazard this person's going to encounter. Is this really an option? Are they, am I really making that option, that hazard, more available to them in a way that's not reasonable? And if you can make that decision and say, no, the product as it is safe, then I'm going to move forward. And if they want to do something else, go ahead. We've got a situation in our industry where some people make products that have different switching devices. You can turn on the product one way or another. And, when you look at it, we've looked at that and made a decision one way. Some competitors have gone another way, which we'll talk about in a little bit. But the reason we stuck with our decision is because we did a very strong hazard analysis. We understood what was going on. I prefer fault tree analysis in some of these things. Fault tree is a great way. I start with the undesired event. What don't I want to happen? I don't want to cut you, burn you, radiate you, chemically, make you ill, whatever that is. I want to figure out what that is. And then I'm going to look at the stack up of events that say, well, how do I get there? How does something happen that allows me to get to that undesired event? And as I figure those out, then I look is, do I have mitigations in the system? Do I have mitigations in the product? And if I don't, that's a great place to step back, consider some other additional mitigations, figure out whether this thing is really an option or if it's needed to reduce that risk to a reasonable level, and then look at your analysis again. So I love fault tree for that. There's a lot of folks that use a European style, like an ISO 12100 method, where you have a matrix and you can do scoring and you can look at probabilities and severities, risk of occurrence and all these things. Also a decent tool. It's not for everybody, but if that's the right tool for you, those will help you to look at some of those situations. And you can look at both situations with and without that device and make a decision on whether or not one really is an option or if you kind of need it. And you can make a choice. Either way, find one that works for you and do analysis both ways. I like FEMA, failure modes effects analysis. I think that's great. FEMA can be a little bit hard in these situations because I think by themselves, what they end up doing is put you in a position where you're kind of limited to your options. You're kind of looking at an A or B, and it's like, have you selected all the right A's and B's? However, I love FEMA from the standpoint of when I get into a situation that fault tree taught me something, or I'm looking at something through an ISO style, now I can use FEMA to analyze that in a little bit of a microcircuit, if you will. I can use that to look at the situation at hand, kind of go through that, trace that problem all the way through, get some answers, maybe some statistics, and then bring it back to my fault tree and see, all right, now what are my probabilities? So again, they're techniques that sometimes work together. And what automotive folks do versus what power tool people do versus what children's products do may vary a little bit, but those concepts really don't. And I think that's the important part, is getting something within your business that helps you understand how you're identifying risk and then addressing it in a meaningful way through objective information. Okay. Another thing that we find very important and I think is critical is understanding your user. I like to, a lot of people like to say, what do they know? And it's important. You do need to know what they know, whether they're carpenters, plumbers, electricians, mechanics, bulldoze operators, all these things. I love to ask, what don't they know? What does that person not understand about this product? Do they not understand it has high torque? Do they not understand it can get hot and burn you? Do they not understand certain aspects of it that if things go wrong, it's not obvious. It's not something that they would generally be aware of. Well, that might help you understand your situation, because if your optional feature is addressing that thing they don't know, that might actually put it over the edge and say, no, it's really not optional anymore, because that's something that they need. But that's something you need to understand. And sometimes it's balancing that person are they a professional or a consumer? Professionals have experience. They sometimes go through training. They go through apprenticeships. There's standards in their field. There are things that are common that put them in a place where that might be something that they're just very familiar with, and they don't need to be told. They don't need that feature. They're very aware, and they're going to avoid that hazard because their life depends on it. Or like electricians who do lines out in your yard and put power to your house. They're keenly aware that electricity can kill you. They're very aware. They've got NFPA 70E that teaches them a ton of great stuff. They follow it. I don't have to teach 70E, but I have to make sure we're consistent with it. But a consumer who doesn't do that, who might be just wiring something in their house on a weekend, adding a circuit, different world. So if I'm making products that go to those folks, they need a little more guidance. They need some guarding, maybe. They need some moisture warnings. They need some instruction. So we have to think about these things when we make our product.
Well,
Um,
can I interrupt for a second there? Give you an
absolutely.
example of what you're just talking about.
Yeah.
Go back to my chainsaw product, since they had a lot of these interesting issues. And one thing that I neglected to mention is that the post-sale safety improvements, of course, occur when standards are changed. And when standards come out with new safety devices, you have no choice but to meet that standard. But that also indicates that there is a reasonable alternative design. And what about the products that didn't, that don't have that safety device from the standard? Well, we had that with chainsaws, and the chainsaw standard came out in 1980, and there were a variety of safety devices that could be added, although we had a choice about which one we wanted to add. So right there, we had a dilemma about which one to put on. But secondly, we had consumer-sized chainsaws and professional-sized chainsaws. And the professional chainsaws, which were readily available to any consumer at Home Depot or wherever, didn't have the safety devices required by the standard because the standard said it didn't have to have them. So there we had different levels of safety, but it was kind of the opposite way, basically, is that the consumer product was safer than the professional product, yet consumers could access the professional product. And that was a dilemma. So at some point, you don't have to do it right now, but you might, because you're involved in lots of standards, you might want to mention how do you deal then with a post-sale safety improvement as a result of standards, and how do you make decisions on what to do about that and how to document that your earlier products are reasonably safe.
Absolutely. And I'm going to touch that. Good point. I'm going to touch that in the next section here when I talk about post sale, but it's exactly right. And
Okay.
sometimes that's what's driving some behavior. So we'll get to that in a second for sure. Um, we're talking about knowing that user, and I think that's important. Another thing is what I think is important is how do those users use your product? And again, and this all folds back. And what I'm talking about here, everybody, is not stuff that is probably rocket science, but are things that we got to think about and put front of mind when we have these discussions. They're actual inputs to your hazard analysis. They should be. And if they're not, you need them to be. So you need to understand your user. You need to understand what they do with that product. What are their common uses? What are their maybe less common uses that you don't really want them to do, but they're going to do it anyway because it's a convenience? This could be one of those what we might call an anticipated misuse. So understanding those is really an important thing. Equally important, and this is something I think we're seeing now as technology advances, is are there new ways to do something? Something might have always been a manual operation where I took a big loppers and I squeezed really hard and I cut something off. But now I can make a powered product that can just cut that off with the pull of a trigger. That's great. But what happens when I put my finger in there? What if my hands aren't where they used to be? What if I'm now doing different things with body positioning? What if that energy can bind up and kick back and now throw me off the ladder? So there's things that we got to think of. So in the old machine, we knew very well what it was. It was very manual. You had a lot of feedback from your product because you were very intimately engaged with it. The powered units may not be. So does that change the behavior? And it's not just what they're doing, it's what could happen if things go sideways. A big one for me is this is something that's really relevant to our stuff and probably to a lot of people is we're moving away energy sources. We're moving from gas engines to batteries. So your lawnmower or your chainsaw might at one point have been a gas engine. It still might be. And you just rip the ripcord and it goes and everybody hears it and it's loud and you cut your grass. With a battery, you don't hear that same noise because you don't have an engine. With a battery, you can potentially push a button and just fire the thing up without having to pull a ripcord, and you don't have that feedback. Who hasn't almost gotten run over by an electric car because it's not, you don't hear it, and you walk off a curb and you don't hear things. You're not used to not hearing things. So there's some things there. Cleaning the product. What happens when your lawnmower is dirty? Do I just take a garden hose and just get at it and hose it down? Or do I clean it up with very careful techniques? In my old gas engine days, I probably didn't care. The engine could get wet all I cared. No one knows. But your batteries, maybe not. So does a cover, Does a shield become an optional safety device, or does it become a thing you need? It's something you really got to think about because it's an activity those users are going to probably perform. Understanding those is important. And then a big one for me, and this is one I'm going to call it a trap, and I don't want to mean that this in a bad way, but competitive landscape. Be very sensitive to competitive landscape. It can be an introduction to what state of the art is or where it's going. And that's certainly something of importance. You need to understand it. And you, as a company, probably don't want to be an island and be the last one to get into it because everyone figured out the safety and you didn't. And for whatever reason, you didn't. And if you get into litigation and you be certain it's going to try, they're going to try and introduce it and it's going to come up. But this is where the trap comes in. Don't just blindly follow the competition. Understand why they did to the extent you can what they're doing. If they added a feature, if they added something, it might be great. It might come with some of those other unintended consequences that could add a new hazard. They could add a new problem. They may not have elegantly done their work and they may not have introduced a solution that actually hits the mark and you can do better. So again, go back to your hazard analysis. And when you look at their feature, go ahead, introduce that into your analysis. Would that do something different? But blindly following because a competitor did it, use some caution there. Also, they might have other features that you don't have that you may not be aware of that may intervene in ways that your product doesn't. So you may not be getting the same result that they do. So again, just use caution, and I just offer that as a practical guidance.
Can I throw one interjection in here? Yeah, well, and I work on lots of instruction manuals, and particularly if it's a new manual for a new product by a company, I'd say go find the best manual involving a manufacturer of the same product, and you want to do as well as or better than their manual. So you want to consider the instructions by the best instructions you can find out there. You don't just copy them necessarily because you may have different features, but also feel free to make them better. And that's okay. So both design and the warnings and instructions could be useful to consider there.
Absolutely. And in our business, and I recommend this wholeheartedly, is consider your warnings and instructions part of your design. I think it's a best practice, but not all of us think of it that way. All of ours in our company are released as a part. Every manual has a part number, every label has a part number, everything is controlled by an engineering change order. You can't just change it for the heck of it. You got to go through a process, but that's intentional because they are parts. They are part of the design. They are something important, just like any screw or guard or anything else. So treating all of those that way makes that a lot harder to miss the mark. But if you did see a competitor that has a great idea, if they do advance the art by applying something new, be on the lookout. We constantly do competitive analysis. We like to think we're a market leader in our business. I know for a certainty that our competitors are looking at our product because people have called me and said, how did you do that? What is that? So it's a good thing to do. It's not copying as long as you, again, do the due diligence and make sure that it's the right answer for you and your users. And then we talked a little bit about regional differences. For years, and I'll talk about circular saws. Everyone's seen one. Carpenters cut wood with them. The Europeans had a device called a riving knife. We never had one in the States. We had this quick acting lower guard that closes in like 0.3 of a second. And we were in trouble because we had a case where a European saw was brought up against us. And what we spent a lot of time with was understanding that regional difference. So we were going to defend our reason for putting our guard on it. And we had all the reasons. It closed fast. It was robust. We could do all these things. You couldn't put it together backward. It was durable. You could throw it around and it didn't break. So it had all the reasons you would think that make our design a proper design. We felt it was very safe and continued to do so. But then we had to understand that regional difference, because what happens when you don't understand is it's unabated to the quarterback. Well, but this would have done this and you have no answer. And now you look like you're just not paying attention. But when you understand it and say, well, carpenters do this, it's a different rule, a different law, it's a historical thing. It may not always carry the day, but at least you have a solid answer you can go on. You can also look at that and say, well, feed that back into your hazard analysis. If there are things that are common and there is a hazard that's common to both and they're doing a better job, well, maybe think about it. And if you're not seeing that, if you're doing it equally, then prepare yourself to understand that you've achieved a reasonable level of safety by using option A and B instead of option B, but each can be safe. but you've chosen this for whatever reason, be prepared to defend that. Ken said something very interesting earlier, and I think it's important, is document your decisions. That's always something to be careful about. That could be a webinar of its own. In fact, I think it was, but be sensitive to that. Find people that are professionals, get strong legal advice, help make sure that your process is going through all the right steps and you're documenting those so that if you do have to use them defensively, you can do that. I like to look at it as offensively and say, no, if I document myself well and make good decisions, when I pull that file open to do generation two, I've got a great head start. It doesn't mean I want to copy generation one, but I've got a great head start on my decision matrix in my process. And now I can go do that again and get to a great decision on gen two. So, but again, get your feedback. Sometimes these aren't options at the front end of a design. So you're not weighing your design, you're getting into the post-sale world. So you've made the product, you've made a decision, you're extremely happy with it. And then you put it out in the world and now you're thinking about making your generation two. You're thinking about the next step. And it's okay. As Ken put out there and those slides show you, the law allows you to do that. But again, let's understand some things. Is what's motivating the change? Was it a standards change? Are people doing different things? For instance, siding. For when I grew up, everybody used aluminum siding. It was great. I don't think you find much aluminum siding anymore. Now a lot of vinyl siding, concrete board. There's different materials that are used. That's important. Norms have changed. People stopped using certain types of roofing materials and now they're going to other kinds. Okay, that's fine. But understand what's motivating that change because it's really important. And if you're, or what if you got new technology? What if when you made your product originally, you didn't have it? People like to use the term AI or machine learning. It sounds really sexy and it's a great thing. Well, that wasn't available 10 years ago in the way that it is now. So utilizing it could be a great thing. Utilizing it properly is a really important thing. So be careful. I wouldn't suggest you have Chat GPT or a program like that writing your operator's manuals for you. I think you still want to do a great job. But if you can use those types of techniques in your product to learn something, to teach it something, to shut itself off, to diagnose itself better, great. And sometimes those can be what look like safety improvements, but they just weren't available at the time when you develop it. Understand that and then use them properly. If you are addressing customer complaints, this is where you got to be a lot more careful, is when you're out there looking at your product and you start getting customer reviews that aren't great, or you're getting social media blog stuff, or you're seeing YouTubers kind of setting some up or influencers. God forbid you have claims or litigation. Now you got a different thing on your hands because now that motivation it could be a safety motivation. And if that's what you're coming down to, you really got to think about it. Is that what are you going to do here? And it's always right to do the right thing, even though it can be painful. So if I have to make that improvement, you've got to make it. But now you start thinking of some other things. Instead of just making a generation two that has new technology, I'm actually addressing a problem. And now I've got to start thinking about what happens to the products I've already sold. And I think Ken mentioned that. Do I have to fix them? Can I even fix them? What level of surgery does it take to retrofit a product? And I think those are things you got to really think about. In fact, you might find that I'm just going to stop selling that old product. That's all great. You'd make those decisions. That's fine. The fact is those existing products still live out there. So while they're out there, what are you going to do about them? So that means you got to also go out and think about, do I need to give some enhanced warnings? Do I need to put notices of availability of something else? Might I have found a problem that requires a recall? Those are all things that you have to be open to and think about. And again, it doesn't mean you don't make the change to generation two because you might have to recall generation one. That decision should be on its own. If you've got a problem in generation one that you learned about, take care of it. And if part of taking care of it is creating generation two, then do so. But again, be prepared to do both because it's important. Because at the end of the day, that's what your consumers and your customers are expecting. So I think that's about all I had from that side, Ken. I don't know, we can save the rest for questions, but I think
yeah. Well, we'll turn over to Roland and see if there are any other questions. One question that did come up actually, which is a nice segue to the patent area, is a question came in about what do you do when a company develops a safety improvement, but they won't sell the patent rights. They won't allow manufacturers, OEMs, to use that safety device unless they paid lots of money for it. And the current example involves saw stop, and which involves the table saws. The one I had experience with was the immersion detection circuit interrupter (IDCI), which was developed by Leviton, the electrical component manufacturer, and they didn't want to. They wouldn't even sell they wouldn't even allow anybody to use it, even if they paid for it. Well, the CPSC got involved and they made them change it and made them offer that safety improvement to all manufacturers. So I don't think they're doing that with SawStop at the moment. But have you had any experience like that?
You bet. You bet. In fact, saw stop's a great example. I've been working with table saws on that exact thing since 2005. So there's a lot going on there. And it is. It's a hard thing. And I think, to the extent you want to get into that business, you really got to make a decision on, in that case, it's a table saw. If you're in the table saw market, is that really the right place that you want to stay? Do you want to go and engage those discussions? And if it is, great. Look at the settlements there, not settlements, but the agreements you can make with the patent holder. And if they're not willing and you just can't make it work for your business, can you come up with an alternate that's equally safe in your mind? And then you got to make a decision based on your hazard analysis, whether your solution or theirs is the right answer, or it can be tough and things like that. But one thing that really helped a lot of folks out on the SawStop side was understanding what it does. That's again, it's kind of going back to that competitive analysis. Once I see it, oh, great. If I knee jerk react and just throw it on every saw, I might do it badly. I might do it. In fact, you could encourage behaviors like take the guard off because I don't have any fear of touching the blade anymore because I'll never get cut. Well, that's not true. So you got to be careful with those, but do your analysis, do your work, and then you can decide whether or not what it's going to take to move forward in that area makes sense to your business.
Okay, yeah, and what Mark you said that, which is a whole separate webinar, and that is when is a safety device create a false sense of security? That's a whole different issue. So, but it's a nice segue to Roland Schindler, who's both been a product liability lawyer and now a patent lawyer. And just give me a second while I change the slides here, and hopefully, Roland, we can hear you. Okay.
All right, let's see what happens.
Oh, we can hear you. Okay, great.
Okay, great. Before I launch into this, I just wanted to throw in two things. One, I own a 3D printer at home. A month ago, they downloaded new software. It now runs 3 times faster. No changes at all to the mechanicals. So I want you to think about that in the context of what you talked about above, about the cost of fixing something, how fast you can push it out, notice where your consumers are. If I've got a device that's connected to the internet in any way, all those factors are 0, right? I can blow out a fix or a warning right now that goes to all of my consumers at no cost. And so it's something, and also reprogram, right? I can put out a firmware update. So keep that in mind. That changes the calculus if you've got an electronically connected device on all those factors, because you may well be able to mitigate or warn, at least warn, at no cost, immediately, effectively. Mark, I love your process. As a patent lawyer, all I can say is when I look at that, I see 180 octane patent fuel. That is amazing. You could really do some great stuff with that. And so that's one thing to think about. That process, it sounds like it's a regulatory issue, an expense issue. It's not. There's a lot that goes in that can feed your innovation process. And I'm sure it is, just given the quality of the patents that Milwaukee Tool puts out. So let's flip over to regulatory compliance and other issues. Post-sale safety improvements can create a duty to report to the CPSC. The improvement was made. The accidents. Next slide. What that raises is a bigger issue, which is government compliance, right? Government communications. Now, one of the things that we've all run into in life is that you write a document for some purpose with an intended audience. And that audience gets that document, but somebody else sees it. And some shorthand you took, something you didn't explain properly from their world, makes that document look bad. And one of the things that you run into when you're selling products is you've got to communicate with the government about a lot of things. A lot of those communications are signed under oath, under penalty of perjury. And so you make these reports, and you're making them, and they're very specialized reports. They're written in ways that have to be written that way because this is the way that import-export lawyers do it, or this is the way that tax lawyers describe it, or this is the way, you know, your EPA people want this said. But when you take those out of their context, they become a little more complicated. And so one of the things you have to watch out for, and it typically, right, that was expensive. You remember Erin Brockovich, right? To find out that they had the chromium in the water, she had to go out to this little hut in the middle of nowhere and sweet talk her way into the back room where they had the records. Today, that's probably 2 clicks away, that information. It's all digitally collected, it's all online, and it's easy to track down. So one of the things to think about, and as you're selling products, is making sure that your communications are consistent with the things that you want them to be consistent with. A good example of this is the one that we talked about a moment ago, right? This is the professional version. This is the amateur version. Now, how's that going to look if you get to trial? And your part of your defense is, hey, this was the pro version. You bought the pro version. And somebody pulls up an import document that says, you know, consumer saw for the same product, right? Going to be hard to argue that. You've represented in writing to the government that you've got a consumer saw, and you're trying to tell me now it's your pro saw to get out of this litigation. You know, that's not going to help you. And so one of the things you have to watch for is just try to, you know, it's not easy, but make sure you're consistent with the things you claim. If I claim it's a toy at the border, I can't say, no, I didn't sell it as a toy. How's that going to look? Right? There's a lot of things that can happen that way. If you say that doesn't have phthalates and your effluent report from the plant still has phthalates in it, even though it's probably residual, that's going to be hard to explain. So make sure you do explain it. And the worst documents of the time are the patent documents. Patents are big, expensive litigation. You know, personal injury cases, 20 million will get you on the cover of your local bar with the report. 20 million in a patent case is, why did we do that? Okay, there's a different world out there in the patent money. And so every piece of a patent has been litigated, every word, every section, it's all art. It's all rigidly controlled, very esoteric. It's all there for reasons. And because of the way we have to do things, it's easily then taken out of context. Flip to the next slide, if you would, Mark. Or Scott, I can. Thanks. And because everything I do in a patent is signed by an attorney, I'm not going to be able to keep that stuff out just by saying that's hearsay, right? It's made by the party or an individual representative. It's we manifested and acted, believed it was true. That was made by a person authorized to make the statement, right? And so anything you say in a patent has the potential to come back and visit you again. Next slide. Go again. Next slide, Ken.
Sorry, next slide.
No problem. Yeah, no, we're good. So, like I said, patents are things that are new, novel, and non-obvious, right? A lot of stuff is known, though. So if I start combining things and making a patent, examiners seeing what I've done can go back out and Lego brick my thing back together with parts that are known and just say the differences are kind of obvious. Well, it's always obvious when I've given you the playbook. So one of the cores of our craft, though, is to tell the story of the patent so that the examiner and later on your component can't tell you, you know, the jury that, oh, it was obvious. Any idiot could have come up with that. No, there's a story. We got to convince it that there's something new here. And it's kind of got to be baked in up front or it doesn't look like it's particularly real. Let's go to the next slide. And so I'm going to talk about one right now. This is an old one, but it's a good one. It's an interesting one. I did no personal involvement. You'll see the source down below. I'm not making any representations about the factual nature of this, but it sounds about right. Inventors love to tell safety stories, right? That's a great one. It gets the examiner's attention. Problem is, as Mr. Cabanis notes, patents often contain admissions that can be critical evidence. They can prove defect. I don't know if they can prove defect, but they can prove knowledge of how this thing was going to work. If you're saying we didn't expect this outcome and you've got a patent saying this product can have this outcome, that's not going to be helpful. It can show feasibility of alternative designs. I'll give you a couple examples here in a moment. And it can also establish what the state of the art is. It can provide the basis for expert opinions. It leads to witnesses, right? Maybe the person who filed that patent for you is fired now, and they got an axe to grind. Suddenly they've got a name they can go after without even talking to you. Maybe this person is retired, who knows, right? But it opens up whole doors. Maybe the person's from Japan, right? And I only point that out because one thing I learned in my product liability experience was that, is the Japanese language is very nuanced. And the same word that means item or issue also means problem and defect. And so you have to be very careful with translations. If they can get to a Japanese deposition and bring their own translator, you can find yourself in real trouble if you don't anticipate that. So that's another way it can lead to issues for you. So in this case, right, John, if you go to the next page, Ken. They had this thing. It was, you may remember these if you're old enough. This was the three-wheeled ATVs from the 1970s. These things have been around a while. And the allegation was that they roll over because they have a high center of gravity and they have solid rear axles, which means both rear wheels always turn at the same rate. In most automobiles, you don't get that. In this vehicle, you do. They do. And so under some conditions, right, this will cause the vehicle to do one of two things. It can either flip or it can go straight ahead, even though you're turning the wheel. Because it gets this snow plowing kind of dynamic where the wheels turn, but it doesn't grip enough to actually bring the motor device around. And the defense was, hey, these things are easy to turn. Turning techniques are intuitive. And then Mr. Cabanas found U.S. patent number 4,561,518. Next page, please. And what do you know? There's the specific mention to the vehicle in question, the Trimoto, two rear axles mounted in a common axle, chain driven. In the prior three-wheeled vehicle identified above, there is a problem, often encountered in cornering. The natural tendency is for an untrained driver to lean into the turn. Ineffective, makes turning more difficult. As a result, tire wear is increased, right? That's all they said, right? But that's exactly layered right into Mr. Cabanas' attack, is that you knew there was a problem and you didn't do anything about it. And this patent addressed it, and it gives an alternative design, but you didn't put it out there. And so the argument he made, allegedly, was that Yamaha design should have been incorporated, denied it should have been incorporated. Well, how are you going to do that? It says right there, the Trimoto has the problem, here's the solution. And you're saying here in court, no, it's not. It's not going to fix your problem. That's not going to play well. And it led to all kinds of discovery, including the discovery of the patent lawyer's files, which may have all kinds of stuff in there. You don't know. So that's the kind of a dynamic. If you go to the next page, you can get into with these patent dynamics, right? Because you identified a problem, you've talked about the tie to the solution, and away you go. So let's do the next one, again, if you would. So what can you do, right? The patents can they can do all kinds of things. They can make your negligence case. They could sold the product despite the knowledge of the risks. There's a duty, right? Failed to design out the risk. Failed to adopt the state-of-the-art techniques to avoid the risk. I mean, this is separate from based product liability. These are negligence duties, a lot more malleable here, right? Knowledge of risk, failure to properly warn, failure to recall. All these things are duties that will support a negligence verdict. Product liability, all the things Ken talked about earlier. That here's a readily available alternative design. Knowledge of the risk, failure to warn when the risk became known post-sale, right? So you've got all these things that you can pull out of a patent and bring against a party in a product liability case. Next slide. So this is one that I personally was involved with many years ago. This is the drawing to the left is a natural gas wellhead. The way it works is you got the base object, you've got two rubberized layers and a cover plate, and then you've got a screw plate that goes in the top. You screw this thing down, and that squishes the rubber pieces together to form the seal against the pipes. Now, how in the oil field do you tighten that big screw nut? Well, logically, in a situation with natural gas escaping, you smack it with a sledgehammer. What could possibly go wrong? In this case, a chip broke off and caught one of the supervisors in the eye. Go to the next page. So I go into discovery in this case, and I'm trying to prove that there was an alternative design. And the only thing, this company is out of business, the only thing they gave me in the entire pile of discovery was a 2-page sales brochure. But it had a patent number tied to this design. So what I was able to do is I was able to go out and, as part of the patent process, we've got to identify things that have come before us that were kind of like what we're trying to patent. And what happens is when the patent 5 years after my patent comes out, it may reference mine. And they call that searching forward, right? Where I can go look at what patents have ever referenced mine. It's a way of doing your competitive landscaping, right? You go out and you say, okay, here's what I patented. Who's talking about this patent? Because they're probably doing something similar. And so I went out and I did a little fishing. And if you go to the next slide. And I found this baby, right? It issued about a year before the accident. It's got these rubber pieces caught between a sandwich plate, right? You can snap it around the pipe. And then you use a wrench to tighten the nuts. Same sealing effect, no sledgehammers. Now, what I did in that one, of course, we went into mediation and I only produced the drawings, the 4 drawings to the left side of the page. I held on to the one on the right side until we got there and got a lecture about how that design couldn't be used with multiple pipes because they didn't bother to read the actual patent. And I said, well, here you go. I meant to show you this earlier. We were out of there in about an hour. But that's the point of it, right? There's a reasonable alternative design. It works with multiple pipes. It's easy. It makes sense. Why wouldn't you use it? And that makes short work in some cases if you do your patent work. Next page, Ken.
No, those were the slides I took out.
Okay.
Yeah.
Then that's the examples I wanted you to kind of understand here. The other thing that goes on in patents that I want to warn you about is this. Every patent has what we call a claim, and that's the only part of it you can enforce. And so the claim is kind of like your property deed, right? The land goes from here to the post, from the post to this tree, to the tree to the rock and back kind of thing. But the problem is sometimes you put a lot of stuff in a patent, you describe lots of things, and you only claim a piece of it. You try to get it all, but sometimes maybe the examiner says, well, there's a piece of something over here. There's something over here that blocks you from getting the whole pie, if you want to envision it that way. And so you put these fallback claims in that say, well, I only want this piece over here, and I only want that piece over there, in case the main claim falls to some piece of prior art you didn't know about. And so what ends up happening here is you get these dependent claims and you start adding features, you get a little more specific. And one of the ways you get specific is you get specific about how things are going to work. Maybe it's a chemical case, right? And you add in the idea of the inventor comes in and says, look, the formula that works is, between 10 or maybe let's say 50 and 100 pieces per million of this chemical. Now, as a patent lawyer, I got to protect you. Now, I can't protect you if I leave you set up so that if somebody goes 49 or 101 and still gets the same effective product, right? So I'm going to juice those ranges a little bit. We're going to talk about what other ranges might work. And to be safe, we're going to put a little English on that. So it'll probably be, it'll go from maybe what I claim will be 25 to 125. And maybe I'll go 0 to 200, right? Well, I'm your patent lawyer. I'm just working along. I'm not paying any attention to it. What I don't know is that if I say it gets up to 150, it's now toxic, right? I don't know that. And nobody tells me that goes out that way. Well, 2 years later, somebody's looking at your patent portfolio and goes, my God, so-and-so company's using a toxic level of this in their product. So you got to kind of, know where your bounds and meets are on these things and have somebody looking at that just to make sure you don't cross those kind of lines. The other one that I've seen that have gone down that way was an Army patent. They were working on a grenade launcher. And as a dependent claim, one of these throwaway add-in things, they said, well, I guess you could use it to launch tear gas grenades. Well, immediately, oh my God, the Army's doing chemical weapons research again. And this whole dust up blew up because they had this one little dependent claim in there that said something about, gas grenades. So I guess the bigger point of this whole thing is, you should be vetting these things just to think about some of the other things that you might run into. Safety is a great thing to sell, but if safety is not what the patent is, don't talk about it. If the patent is about safety, if it's about turning the device off when the finger gets near it, fine, talk about it. But don't add it, throw it in there and get excited about it, because the safety is, at the end of the day, it is not an absolute concept. The word safety is in this context, with this product, with this use, you have reduced risk. That's really what we mean when we say safety, right? But if I claim it as it's safety, Well, it's sort of absolute. Just talk about the technical effects and stay away from the issue. That's sort of the best way to manage this is just, if I do this, this happens. When they first introduced anti-lock brakes to cars, they introduced them not as anti-lock brakes, but as improved ability to steer and turn. That's the technical effect. And that's what you should focus on.
Can I interrupt, Roland? Because I want to wrap this up. Can I kind of summarize this part? And I'm speaking as a product liability lawyer, not a patent lawyer, but I used to review patent applications. And what Roland said is exactly right. Basically, if you're dealing with a safety issue in a patent, have somebody who's going to have to defend cases or has already been defending cases so they know that they'd be sensitive to the way you say it. And you don't want to have the patent application admit your earlier product is defective unless you intend to recall that product. But I mean, you don't want to say it anyway because that's going to be used against you in a case. So it's just be mindful of that. Very few patent lawyers know product liability too, unlike Roland. And that's about the best we can say. But hopefully you understand from the discussion of the law the kinds of things that will be considered and the kinds of words that could be used against you. And it's just a matter, it'd be nice to tell you exactly what to do, but we can't, we rarely can ever do that. It's just you be mindful of that, be mindful of the potential risks of doing a variety of these things, whether it's optional safety, compliance with standards, post-sale safety improvements, patents, all of these things. Be mindful of it and be sure that you have people to comment on these things who know that area and can give you very quick advice on how to word it or what to do and how to document the process. That's the main message here for all of it. So I think we've come to the end of our time. I want to thank Mark and Roland for your contributions. Thank you all for attending. We will be posting the slides and one or two other things that relate to the topic. And thank you all very much and have a great rest of your day.